For nearly 150 years, being born on American soil meant you were automatically a U.S. citizen, regardless of your parents' immigration status. This principle, known as birthright citizenship, was enshrined in the 14th Amendment to the Constitution in 1868. The amendment's citizenship clause states, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside." This guarantee overturned the infamous Dred Scott decision and ensured that all people born in the U.S., regardless of race or their parents' status, would be citizens. The Supreme Court reinforced this in 1898, ruling that children born in the U.S. to immigrant parents are citizens at birth. For generations, this promise was a core part of American identity and law, providing security and opportunity to millions. But in 2025, everything changed. On January 20, 2025, President Trump signed an executive order titled, "Protecting the Meaning and Value of American Citizenship." This order, along with a new bill in Congress, aims to end birthright citizenship for millions of children born in the United States to parents who are neither U.S. citizens nor lawful permanent residents. Key details of the executive order. The order targets all children born on or after February 19, 2025, who do not have at least one parent who is a U.S. citizen or lawful permanent resident. It applies to children of undocumented immigrants and those whose parents are in the U.S. on temporary visas, such as students, tourists, or workers. Federal agencies have been directed to stop issuing citizenship documents, like passports and social security cards, to these children, and not to recognize state-issued birth certificates that list these children as U.S. citizens. The change does not apply retroactively. It only affects children born at least 30 days after the order was signed. The impact is immediate and profound. Hospitals and state agencies are confused about how to handle births to parents who are undocumented or on temporary visas. Many children born after February 19, 2025, may not receive social security numbers, U.S. passports, or even legal recognition as Americans. Families are left in limbo, unsure of their children's legal status or rights. What does this mean in practice? Two babies, born in the same hospital just days apart, could now have very different legal statuses, solely because of their parents' immigration status. Baby A is born to parents where at least one is a U.S. citizen or green card holder. Baby A is a U.S. citizen. Baby B is born to parents who are both undocumented or in the U.S. on temporary visas. Baby B is not a U.S. citizen, despite being born on U.S. soil. The consequences are significant. Children denied citizenship may not be able to get U.S. passports, social security cards, or other essential documents. This could create a group of children born in the U.S. who are not recognized as Americans, potentially leading to long-term legal and social challenges. Legal chaos and uncertainty. The order has sparked immediate legal challenges. Multiple lawsuits have been filed, arguing the order is a direct violation of the 14th Amendment's citizenship clause. Several federal judges issued preliminary injunctions, temporarily blocking the order from taking effect while legal challenges proceed. However, in June 2025, the Supreme Court ruled that federal district judges cannot issue nationwide injunctions blocking a federal policy for everyone in the country. This means the order can now take effect in 28 states, while remaining blocked in others. The result is a patchwork system. Babies born to undocumented or temporary status parents in some states may be denied citizenship, while those in other states remain protected. A new class of stateless children? Immigration advocates and legal experts warn that this policy could create a new class of stateless children, kids born in the U.S. but denied citizenship, with no country to call home. If their parents' home countries do not automatically grant citizenship to children born abroad, these children could be left without any nationality. This legal limbo can have severe consequences. No U.S. birth certificates, social security numbers, or passports, ineligibility for critical federal programs, barriers to healthcare, education, and legal recognition, risk of deportation to countries that may not accept them, a divided nation. Supporters of the change argue that restricting birthright citizenship is necessary to protect the value and integrity of American citizenship. They believe tougher standards are needed to ensure citizenship is reserved for those with a legitimate, lasting connection to the country. Critics, however, argue that the policy undermines the Constitution's promise of equal treatment and risks dividing the country into two unequal classes. They warn it could create a permanent, multi-generational subclass of people born in the U.S. but denied full rights, entrenching social and legal inequalities. The legal battle isn't over. The Supreme Court has not yet ruled on whether the change is constitutional. More court fights are coming, and the future of birthright citizenship hangs in the balance. Millions of families remain in legal limbo as the courts decide whether America will keep its historic promise of citizenship for all born on its soil, or mark the end of an era for one of its most fundamental guarantees.